How do you trigger the unlawful presence and the bars to admissibility? So basically today we are going to talk about the 3 years bar and the 10 years bar rule, and how do you come about triggering those bars. And basically I'm gonna go over it a little bit in detail, but not too much in detail, just pointing out some stuff so that a person will know whether they have already triggered that, and if they haven't triggered that, so they can avoid it. All right, so let's get into it. So basically the 3 years bar is if you depart the United States after having accrued more than 100 days, 180 days, sorry, 6 months, okay, but less than 1 year of unlawful presence during a single stay and before removal proceedings begin. That's when the 3 years bar gets triggered. So basically the person gets here, and let's say you have a 1 year visitor visa, or let's just say you have a 6 month visitor visa, B1 visa, and then the person gets here. After 6 months, the person stays, and the person stays maybe after 8 months or 9 months, and now they remember, or maybe they've forgotten, right? So now they remember that they have to go back home, and then they go home. Once they get out of the United States after really 6 months, longer than 6 months, which is more than 180 days, but less than 1 year, that person will have a problem coming back. That at that point, the person has triggered the 3 years bar rule. That's how you get triggered. You trigger that one, and then basically they have to stay outside of the United States for 3 years prior to them getting back or asking for a visa, because they have triggered that based on the fact that they stayed longer than 180 days. Then we go to the 10 years. This one is if you depart the United States after having accrued 1 year or more of unlawful presence during a single stay, regardless of whether you lived before or during or after removal proceedings. Remember, you see the difference? It doesn't even matter whether you left before or during the before, during, or after the removal proceedings. But if you have been here and already accrue more than 1 year, basically 1 year or more of unlawful presence, the moment you depart, you have already triggered the 10 years bar rule, meaning that once you get out, you cannot get in until the 10 years has passed. Okay, unless you apply for a waiver. Of course, I'm going to talk about those at the end. And then how does a person triggers a permanent bar? So permanently is if you re-enter or try to re-enter the United States without being admitted or parole after having accrued more than 1 year of unlawful presence in the aggregate during one or more stays in the United States. So it simply means this, okay? You get in the US with a visitor visa, and then the visitor visa expires. Or remember, with the visitor visa, if you have more than 6 months, it simply means that you have to get out after 6 months and come back. But let's say you didn't respect that, the person stays for longer, for 1 year or more, and then they get out. And then once they're trying to get in again without being paroled or admitted, so basically trying to get in back in actually illegally, that person has triggered a permanent bar. Okay, that's how it works. So we have the 3 years, we have the 10 years, and we have the permanent. So that's what I wanted to talk about. So, and then if we go here, accruing unlawful presence, how does a person accrue unlawful presence? If your presence in the United States without being admitted or parole, or you have remained in the United States after expiration of the period of stay authorized by the Secretary of Homeland Security. Okay, so the same thing I said, if you had a visa, visitor visa for more than 6 months, it simply means that you have to get out within that 6 month period of time. The moment you go, you pass 6 months and you just get out after that, then you have triggered those bars. If you go before a full year, then you've triggered a 3 years bar. If you go after 1 year or 1 year, then you have triggered the 10 years bar. And if you have attempted to come back after remaining, basically after leaving the US for, after remaining in the US for a full year, and then you attempted to come back without being admitted or parole, you have triggered a permanent bar. That's how it works. So now there are a couple exceptions. Okay, they said the law also provides exception for accrual of unlawful presence to the following individuals. So we have asylees, time while a non-frivolous, okay, has to be a good asylum application. So time while a non-frivolous asylum application is pending is not counted as unlawful presence. Let me be clear. So the moment you apply for your asylum, that time is not counted as unlawful presence. But let's say you apply for the asylum and then you want to adjust status, not to marriage, because with marriage it's much easier. You just have to show with clear and convincing evidence that the marriage is a marriage entered in good faith. Whether your asylum case is pending, you are going to be able to adjust status. But if you want to adjust status while your asylum case is pending, to, let's say, your child turning 21 and want to apply for you, what's going to happen is they're not going to say that you are lawfully present, but unfortunately they're going to say that you are not admissible because you did not maintain a non-immigrant status at the time of the application. So that's the language they're going to use. At that point, now you have to come up with an argument. We've talked about that before in my previous videos. You can refer back to that. So that's the point I wanted to make on asylum. And then we have minors. Children do not accrue unlawful presence while they are under the age of 18. So let's say a child, when they're 17 and a half, they apply for some type of relief, then they're not going to be inadmissible based on unlawful presence because they do not accrue unlawful presence. Okay. Family, when they're under 18, of course. Family unity beneficiary, individual with protection under the family unity program as provided under the section 301 of the family do not accrue unlawful presence while that protection is in effect. Those are especially when it comes to marriage, when your asylum case is pending. So at that point, it's based on family unity. So you're not really going to they're not going to talk about unlawful presence. At that point, they will talk about just to prove that the marriage, with clear and convincing evidence that the marriage has been entered in good faith. Okay. And then another exception we have for batters, spouses, and children that vow petitioners. And vow petitioners, self-petitioner under the Violence Against Women Act do not accrue unlawful presence if they can show a connection between the status violation and the abuse. So basically, you have to be able to show that the reason you have accrued unlawful presence, it's based on the abuse that you suffer from your spouse or a U.S. citizen, of course, and then or lawful permanent resident. If you're a spouse or a child, then it's going to be the parent. So as long as you can prove that, then you are not going to be required to file a waiver of to waiving that unlawful presence. And then we have victims of severe forms of human trafficking. Those are T visa, of course, recipient. The trafficking or U visa, depending if it's really serious trafficking victim who can show that a severe form of trafficking was at least one central reason why they were unlawfully present in the United States, they will not be considered inadmissible due to unlawful presence. So they can adjust status if they can show that. So only 1, 2, 3, 4, 5. Only 5 exceptions when it comes to unlawful presence. Okay, only 5 exceptions. If you don't fit any of those exceptions, there's hope you can apply for a waiver. So we'll talk about it at the end. So now, let's talk about the 3 years first. It says this 3-year inadmissibility period when you depart or are removed from the United States. Remember when we were talking about deporting, some people don't just leave, they just stay. But when it's more than 6 months and less than 1 year at the time you file for adjustment of status, still you will be within the time frame of unlawful presence, and you'll be within the time frame of the 3 years bar rule. So, and then what's going to happen, unless you have those type of exception, if you do not, that's when you have to apply for a waiver. Okay, so that's what it's saying here. During that period of time, you're not going to be eligible to receive an immigrant permanent visa or a non-immigrant temporary visa to come to the US. If you're outside, adjust status. If you're inside to a lawful permanent resident, you cannot be admitted to the United States at port of entry. You cannot. Okay. I wanted to read this one so I can talk to you about the exception. Just give me one moment. So it says that this bar does not apply to you if you accrue more than 180 days, but less than 1 year of unlawful presence and left the United States after the commencement of removal proceeding, but before the 1 year mark. Okay, so the difference, it's not the difference, it's just some type of some specifics when it comes to the 3 years bar. Remember that the 3 years bar is when you depart the United States after accruing a lawful presence for 180 days, but less than 1 year, and you get out. And that's before the removal proceeding, right? When you get out, you cannot get in until after 3 years. But if you deported after the commencement of removal proceedings, that you are within the exception. So you can always try to apply to come back in. Okay, that's what they're saying. It could be, but still you can be you see how they're wording this, but you could also be inadmissible to failure to attend the removal proceeding, and then the judge order you in absentia, so without you being there. So you're not going to be inadmissible based on unlawful presence, because that exception here applies, but you're still going to be inadmissible based on the fact that you failed to attend the removal proceedings. So the judgment was entered in absentia, basically without you. So that's where your ineligibility will be based on. So either way, it's still inadmissible, but on a different ground. So the 10 years bar rule says that you're not going to be the same thing. You're not going to be eligible to receive a immigrant or non-immigrant visa. If you're inside, you're not going to be eligible to adjust status or admitted at the port of entry. And then the permanent one, basically, we already explained that, is when a person, after accruing a 1 year and or more of unlawful presence, they leave the United States, and then the person attempts to re-enter the United States without admission or parole. That's when you trigger the permanent unlawful presence bar. Okay, the same thing, consequences are the same thing. You cannot receive an immigrant or non-immigrant visa, just you're starting in the United States, or be admitted to the United States port of entry. Okay, so now what is the solution? Okay, we always have to talk about solutions as well. So what is the solution? The solution is this: if an unlawful presence bar applies to you, what can you do? You have to just look into waivers. We have the common one we know is I-601, I-601A. This one is only for application for provisional unlawful presence waiver, and once it gets granted, you have to get outside of the United States and apply for visa through consular processing. So basically out. This one, whether you're in or out, you can apply for this one. This one is applies to whether you are in or outside, but this one is very specific, and you can only apply one form. Only this one. It cannot be combined with other form when it comes to I-601A. And then we have this one, I-192 application for advance permission to enter as a non-immigrant, as another form of waiver. Usually this one goes with people who apply for U visa. Usually they go with this one. Another one is I-212 application for permission to reapply for admission into the United States after deportation or removal. So when you combine this one can be combined with this one as well. The I-601 can be combined with this one, basically when you're asking for permission to reapply, because remember, if you've been removed, now you ask first of all for ground of inadmissibility waiver and for permission to reapply. So that's in case you have been deported and you're outside. So this one and this one goes together. Okay, so that's it for today. I just really wanted to talk about those bars, like the 3 years, the 10 years, and the permanent, and how really can you trigger those bars. And we talked about it. I am going to leave the link in the description box. If you have questions, please do not hesitate, contact me. Information in my description, in the description box on my YouTube channel. Consultation fees applies. Again, I charge $175 for consultation. Our phone number is 202-751-2180. We'll see if you qualify for any waiver if the person has been really based on ground of inadmissibility, so we can find that. So that's it for today, and then until next time, bye bye.